The law relating to children was the place where Lord Donaldson explained most explicitly his understanding of the limits of legalism in the context of healthcare law, and where he pointed out it was a deliberate decision to leave some things for professional judgment rather than to be dictated to by legal rules. And he also put great store on the fact that giving greater freedom to doctors to exercise their judgment was something that he thought was appropriate, partly because he believed that they were governed by their own set of values, and the moral values of medicines were things that he thought it was appropriate for the law to support. And that's what I've sometimes described as the integrated view, the idea that the judges assume that there's an integration between medical ethics and healthcare law. So you can see that in the adolescent treatment cases that were decided by Donaldson and his colleagues in the Court of Appeal. But you can also see other questions at play. You can see the tension between flexibility and certainty. So in child law generally, not just in the healthcare context, but generally, we put a lot of play on the idea that we should try and act in a way that's in the best interests of children. And that leaves it very difficult to predict how circumstances will lead to outcomes. And some commentators, such as Sir Ian Kennedy and also Jose Miola, have suggested that the best interest test abdicates legal responsibility because it's either hiding the principles that are at play or it's just too vague to provide oversight. So the child law is the context in which those things are fought out. But it's also an area where people see a battle between clinical power and parental power. So in relation to decisions about withdrawal of treatment, a decision needs to be taken whether it would be a matter for parental choice subject to them being unreasonable, or whether the key issue is that clinicians should be permitted to do what they think is best for their patients and protect their patients, even if that means falling out with the families. And that's a key theme in many of the cases in the child law context, because of course if clinicians don't fall out with parents, things never need to get to court.